Was Deborah, thank you for that question. The Supreme Court judgment did not go far enough to specify the individual, the outcome for each individual affected and caught up in the dragnet of military justice. It was clear only for those who had pending trials, pending charges, and thought they would be reappearing before the military courts. Those have clarity, some clarity, that they will now be appearing before civilian courts. However, it is fraught with confusion insofar as it states that there shall be a transfer of cases from the military system to the civilian system, and there shall be an intervention of the DPP. It's also fraught with confusion and some, honestly, chaos when it categorically says that there is a class of citizens that won't benefit from its declaration. All those whose situation had been conclusively dealt with before the 31st of January. So we have constituted a think tank to review this judgment and advise us on how to deliver customized justice for each individual, each victim of military justice as things stand. Because that's the duty of the bar in terms of Section 3, subsection D of the ULS Act. We must account to each member of the public. We must ensure that each member of the Uganda public gets the best treatment under Ugandan law. That Ugandan law is administered fairly and justly in respect of each individual without discrimination. Again, under Section 3, subsection E, it's our duty to assist the courts and the government in the proper administration of law. So the enforcement of this judgment in clear terms for each individual is our responsibility as the bar. And we have constituted an advisory team to give us a roadmap for each individual's case. What we know so far is the following, that there are individuals that have counsel. For instance, the petitioner or the respondent in the case, Michael Kavaziguruka, and some of the highly visible individuals you know of, who already have counsel. Their counsel are ably competent to process a pathway to justice for their clients. And I think you cited an example, that there are those who have taken the route of putting before the High Court an application for habeas corpus. A habeas corpus application asks one question before the court of law: what is the legality of the detention of the subject of this application? How does the government justify continued detention of the subject of this application? And then there will be a contest in respect of that particular person. Our case is that those individuals have some privilege. They have a friend, a relative who has some means to engage private counsel to put before the courts of law a habeas corpus application. Habeas corpus is the most significant right in the Constitution. It makes the High Court an investigator on behalf of every person whose detention, whose liberty is presently deprived by the state or some other authority or even some other person, including a child, I believe, a child who is not in the custody of his mother, can be the subject of a habeas corpus application. Who was, under what law is this other person in custody, in possession of this child? So that complements what my colleague has said, and the treasurer has said that it's not yet uhuru. This Supreme Court judgment falls in the what Swahili would call nusu mkate. It provided an interpretation of the law which is resounding. The end of civilians before military courts. That era is over. But as to whether it gave effective remedies for the victims of a system of justice that has been found unconstitutional, that's debatable. And in due course, not so far from now, our think tank will have provided a thorough analysis and a pathway to justice for each individual. So that process is ongoing. It's expensive. It involves, as the treasurer said, accessing data. We want to be able to put a name, a face, a story to each individual. They shouldn't be mere statistics. We should know them. Some of our legal aid projects, especially in the hot zones like Karamoja region, have started to give us data sheets of their clients. Those they can account for, but even that data is subject to the qualification that there are many they can't account for. So military justice in Uganda was accompanied by another violation known as enforced disappearance. I mean, the military had no business in the first place arresting Ugandans. They don't have the power to do that. All right? So all those arrests were illegal. The detentions were illegal. The trials were illegal. Was the Supreme Court correct to say, let's close the curtain and move on? That's a question for our think tank to answer. And we shall invite you, not so far from now, to provide you this answer. But you're correct. The country is now celebrating nusu mkate. And that doesn't provide relief and closure for so many Ugandans. That's why we are addressing you now and saying that we are reconstituting ourselves completely as a clinic, as a legal aid clinic of a special nature to address the outcomes of the Supreme Court judgment. I hope that answers you fairly. All right.
Yeah. Is that a question, I think?
Thank you so much, President. There are some questions coming online.
Adam, just a moment. His, I think, is also answered. Yours was, what is the law as it stands now? And I want to believe that the explanation given by the President has somehow, or has answered your question as well. Oh, thank you. Adam, you may proceed.
Okay, thank you so much, President and VP. There is a question online, which is almost the same as Deborah's question, but this one is asking, was the Supreme Court clear on where the convicts in the court-martial should go? Should they be set free, or should they go to the civilian courts? What is the basis of this, and what does the law require? Remember, the DPP did not sanction these charges. And then another one says this question goes to the treasurer, that is Collins Mutumba. This goes to the treasurer. How broke is the bar please set a figure. Secondly, why is the bar looking for money? How did we get here? And then the last question comes from Jeremiah Sekabira. Jeremiah asks that what is the future of law practice? I think this regards digital transformation as the radical new bar agenda. What is the future of the legal practice in light of the advent of artificial intelligence that we saw our president, our job safe? Thank you so much. Those are the responses coming online.
Maybe before we go back to the law, Treasurer, you can come and speak.
Council Collins Mutumba, what do you want to cause to Uganda Law Society? Of course, you may not know, but let me inform you. We have so many dates. Yeah, we have dates with. We had recently an AGM that happened in Munyonyo. We have the diary issue, and so many others. So I think it wouldn't be very prudent to mention how broke we are, because we even told the people demanding ULS that they should hold on. Please hold on, we are looking for money. So imagine a situation where I state that we have this much. Yeah, they would say cancel. But that aside, we reached here because of why did we reach where we are? Why do we say the buy is broke? There was an issue of poor planning. The planning wasn't as good as it should have been. And that is why currently we are setting into motion. We are hiring an internal auditor. We are hiring a procurement officer to ensure that we are perfectly in shape to handle the finances of the society. That is how I can answer that question that has been asked by my colleague, Councillor Collins Mutumba. But I have, in private, you can always come and I give you a better picture of the finances of the society. Thank you.
Maybe again to compliment Treasurer before you leave. I think our colleagues may not know that we stand in the unique embarrassment of being a statutory authority, a body established by an act of parliament to perform specific functions, such as Section 3C, to protect, represent, and assist all members of the legal profession. That is, practicing advocates, academics, students, in all conditions of practice or otherwise. That's a very broad mandate. As long as you're concerned with the legal profession, bailiffs, clerks, we are statutorily obliged to protect you, assist you, and represent you in every aspect of your engagement with the legal profession. 3D, to protect and assist members of the public in all matters touching on the law, ancillary to the law, and affecting their engagement with the administration of law. So, we are the Mulago Hospital. We are the national referral law firm for all members of the public. For any reason, we do not question why you have come and chosen to run to the National Bar Association with or without your lawyer. And many people do expect us to be a public watchdog as far as the administration of law is concerned. And 3E, to assist and advise the government and the courts of law in the administration of the law. So again, the state has given us these responsibilities. But even without the state, we would have these responsibilities as the National Bar Association arising from the right to a fair hearing and its interpretation in terms of the UN standards for independence of the legal profession and the IBA standards for independence of the legal profession. The UN instruments, I think the most important instrument is the UN, basic principles for the role of lawyers. This is the 1990 agreement. We call it the Rome Agreement. We also have a Rome Treaty. So both the UN and the IBA, the International Bar Association, met in 1990, August to September, and agreed that every country that follows rule of law must have an independent legal profession. Now, that entails certain duties. The unique embarrassment is that we are not funded by the state. We must be funded independently. We must be independent of the state. We must be jealous about our independence. So we must not accept money that can affect independence of the bar. And that's why the state hasn't funded the Uganda Law Society directly. So we don't receive a subvention from the National Treasury to do these important duties. Yet we are expected to be available at all times as public watchdogs in all facets of legal administration. That requires individual lawyers to pay for the strength and independence of the legal profession. So lawyers up to now are charged fees by the National Bar Association to enable us perform functions 3A and 3B, and maybe minimally 3C. 3A and 3B are about, our role in facilitating their enrollment and their ethics, their continuing professional development, and their dinners and community. So members can understand the 500,000 shillings they pay for that purpose. They have also been gracious. They are paying up to 500,000 shillings for the ULS House Fund, in addition to subscription. So they are paying for the ULS House Fund. That's a specific fund. We can't touch that money and say we're applying it to these clinic duties. No, it's for the ULS House Fund. Members desire to have their headquarters in Kololo. They have approved plans and so on and so forth. So the other thing they are paying for is benevolent fund. Yeah, health and benevolent fund. They pay some 75,000, I think, which is again earmarked for that purpose. So we are not yet there. We recognize the harsh conditions of practice in which our members generate the income which they share collectively to perform this statutory function. It's just not enough. We already have an existing legal aid project which our members have paid for through toil, sweat, and blood, and with the assistance of initially sister bar associations. The Canada Bar Association, I believe, was among the earliest supporters way back 1992. Yeah. The Norwegian Bar as well supported, and then over time institutional and governmental support has provided us a resource envelope to maintain our legal aid project. But institutional and governmental support towards our legal aid project is earmarked for specific legal aid units or legal aid clinics in specific districts addressing specific situations. So if we have emerging situations like this judgment that fundamentally alters the justice architecture for this country, we have to have new conversations about whether the existing rota of donors to our legal aid program want this new intervention. That's a conversation that they must come to willingly and voluntarily. And maybe they are understanding and studying this decision. But we have to lead. Whether or not we have institutional or donor support from development partners, we have our best assets, and that's the goodwill of our members, who require us to have direction, to be clear on what our priorities are as a governing council, and tell them that we are inviting them to direct their advocacy in a particular field. And that's what we are doing, though we know that this is not an ordinary cup of, this is not anyone's ordinary cup of tea. And until the military and the security establishment and the government take a more benevolent attitude towards the judgment that just came, it means there's going to be further contest. The Supreme Court decision has not resolved everything. Clear? It's not yet uhuru. This is half a loaf. It's better than no loaf at all, but it's still half a loaf. Okay? So, to walk the last mile for each victim, and some of the victims are long dead, but they are still victims, and the trauma and the scars have been felt by people who still live, and they want redress, they want reparations. This judgment is a Pyrrhic victory for them. Okay? It sounds nice in legal rooms like this, but it doesn't address the injustice of they came into our home in the night, terrorized us, and held us for days on end. Where is the justice for that? So that's our inquiry. It's a national inquiry, and it would be wrong to just bury these injustices and move on. As the National Bar Association, we are taking the policy decision that we welcome the Supreme Court decision for clarifying that aspect of the law on jurisdiction, but as far as effective remedies are concerned, that's a whole new war zone. And we have to prepare a war budget for our warriors. And that budget is significant. It far outstrips what the legal aid project has received before. I think that's the haircut figure. That's the ballpark figure. Deborah, to help you understand, that figure is in the range of what we have been receiving for the legal aid project, give and take, or for a special project like building this house. The cost of providing redress to all victims of military justice for the last 30 years since the establishment of the UPDF is honestly earth-shattering. And we shall be guided, as I said, by the members that have agreed to sit with us and think through all the options we have and budget it accordingly so that we can have structured conversations with well-wishers from the public. The question about the legal clarification, I think we've said this enough. Take it home. The court was emphatic, 100%, that there shall not be another sitting of a military court. I think not only for civilians, but also for military officers. Not another. They could sit if they want to decide the question of dismissal. That power is still theirs. But criminal justice. Everything has now to, they must use the ordinary courts. Now, I think somebody raised the question, is the DPP properly empowered to squeeze herself into these cases and purport to continue them? The short answer is no. No. Civilian justice starts from police, first information. So all these cases, if they are to be transferred, they can't just be leapfrogged into court. If they do that, we are going to challenge that as the National Bar Association. Civilian justice starts with a first informant reporting before a police station. It doesn't matter who you are, whether you are the president, whether you are the head of intelligence, civilian or military intelligence, you must report to police, and the police must conduct a fair investigation. And the police cannot start by detaining people. So there is, in that respect, the judgment has far more, it raises far more questions than answers. And we don't want to use today's forum to speak in very conclusive terms. We have a think tank that has asked for some time to process clear answers to these questions, and we shall review those answers. But the other reason why we don't want to be very specific in how we open up this can of worms is because we don't want to preempt the institutional engagements we are going to have with every department of government concerned. Hopefully, the clarity will come from the government itself. It will come from the DPP, from the police, from the civilian authorities responsible for justice. So we want to give them time as well to reflect through the meaning of the judgment and the obligations they now have towards each victim of military justice. We hope to speak after them, but we will not be waiting forever, okay? If they have no clear answers for the taxpayers, within 1 week, we will be back. We'll be back, and we shall be very bold and vocal, as usual, as you've come to expect of the Radical New Bar. I hope that satisfies Q&A, and we'll close this business. Any other question? Don't have to be, yes.
Good afternoon to everyone. My name is Counsel Edwin Tobias. I'm working with Zika Advocates. My question is, what is your response to the president's statement? Because we saw the president coming out to undermine the decision of the judges. He also undermined the rule of law. He undermined the principle of separation of powers. So what is the Uganda Law Society response to that? A friend of mine called Brenda Jiduda has also sent a question asking, when are we having a real CEO? Because we have an acting CEO, but when are we having a real CEO for Uganda Law Society? Thank you.
Thank you. Is there any other set of questions before we close this session?
Yes, okay, thank you so much, President. This question comes from WBG iPhone, that's the name he uses, and he asks something related to Parliament. What would be the remedy, additionally, if it's possible for Parliament to pass laws in future that allow General Court Martial to try civilians? Would this be legally possible and okay? That was the question.
So I want to start with the question of the CEO, Mr. Tobias. I think that's a matter for the governing council. All right? Yeah, we will, in due course, as guided by the matters upon which we are briefed, provide a pathway to a substantive CEO. Yeah. But we had a retreat last week, yeah, to look at the institutional management architecture for the institution. And in due course, we shall communicate outcomes, yeah, after doing that important house cleaning function. So members should not be so anxious. It's a non-issue. It's not out of the norm to have an acting CEO. Yeah. The second question is Tobias, there is no such statement from the executive, okay? And so we shall not comment about non-existent things, all right? Yeah. Yeah. Oh yes, you should be very worried about the future of your profession in light of AI. And lawyers who are not using AI should be condemned to the dustbin of history. Okay? So, but to help ensure that you still have a legal profession and you're still active, we have again convened a think tank that will guide the transition, not only for the bar, but also for the judiciary and the government to operate alongside AI as a multiplier force in the delivery of justice. The government, more than a decade ago, passed e-governance laws, but it hasn't really started to implement them to the satisfaction of the taxpayer. The taxpayer is paying a lot of money to e-governance programs, but there's little accountability. So any lawyer out there worried that e-justice would erode or degrade the legal profession should drop that sort of mindset. They should become perpendicular with digital transformation, but they have no cause to worry. The current governing council intends to assist them fully become compliant and perpendicular and alive and lively in their profession alongside AI and other digital tools. So again, in the course of time, we will lay out our plans, not only for the immediate short term, but for the medium term and the long term, how to improve legal services using technology. How much time is that? 20 minutes. Okay, so we would like to close the Q&A for now and have the next item. Can I help you, CEO? It's my honor and